Giddy up. Ladies and gentlemen, we'll call to order the Board of Public Works and Safety meeting of August 1st, 2013. Roll call. Here.
Here.
Item A, we have a bid recommendation from Nice Engineering recommending that the project be awarded to the low bidder. Who is the low bidder? Walsh and Kelly, with a bid of $705,645 for the reconstruction of Willard Road.
I'd like to make a motion that we accept their recommendation and make the award to Walsh and Kelly. Second.
All in favor?
Aye.
Aye. Motion carries. Item B, we have correspondence from DLZ regarding the bids that we opened on the athletic complex at Dowling Park. Their recommendation is to reject all the bids. This is based on the fact that the city was not able to acquire certain property that was going to be used in the project, and we will be redesigning the project accordingly. Is there a recommendation or a motion?
Yeah, and it states in a letter that they're hoping to go back out to bid during the month of October. So I'll make a motion that we accept their recommendation and reject all of bids. Second.
All in favor? Aye. Motion carries. Item C, we have a change order from First Group Engineering, just for the reconstruction of Columbia Avenue. Change order is in the amount of $6,270.
And our share is $1,200. 80% federal. So I'll make a motion that we approve the change order. Second.
All in favor? Aye. Motion carries. Item D, we have a engineering supervision contract with Nice Engineering for the Willard Road reconstruction project that we just approved.
I'd like to make a motion that we approve the supervision contract with Nice.
Mr. Destatny, what's the value of this contract?
Yeah, normally I write it on the front. I forgot to do that.
I put a tab by it.
What?
There's a tab.
$70,060.
All in favor?
Aye.
Aye. Motion carries. Item E, we have a correspondence from Councilman O'Pinker, Mayor McDermott, the Engineering Department requesting $5,000 be transferred from gaming to the Engineering Department for sidewalk replacement in the 5th District.
I'd like to make a motion that we approve the request. Second.
All in favor?
Aye.
Aye. Motion carries. Item F, we have several properties that the Building Department is requesting advertising dates for demolition Thursday the 29th.
I'd like to make a motion that we set the bid opening date of August the 29th with advertisement dates of August 8th and August 15th. Second.
All in favor? Aye. Motion carries. Item G, we have a hearing on the property at 232 Ogden.
I believe Mr. Cook and Mr. Matthews, the attorney representing them, are in the hallway discussing this matter. Maybe we can bring it up when they come both re-enter.
Want to go to item H?
We'll do that. Item H, 851 Indiana.
There we go.
My name is Jesus Pellicana, here representing 851 Indiana.
Are you the owner?
Yes,
This was they said they didn't get service for the hearing dates. On one of the hearing dates, the board affirmed that the property would come back to a 2-unit. They did provide drawings at one time, how they're going to convert it, keep it as a 4-unit. Drawings were inadequate. They were informed as such. We went from there, never got any other drawings, board affirmed the 2-unit.
I appreciate Kelly's interpretation of the situation, but I'm under different, I don't understand. we had discussed some things when they did the initial inspection that need to be brought up to code. I got the contractors, they brought in the proper paperwork. We came once or twice here and he did request drawings. The final thing that I was told was to go ahead and finish, if I could finish in 30 days. I said yes, and that was the end. Right upon the time we were about to finish, they put a halt to it and said there was no permits pulled. But I got copies of all the permits, signed off. I don't understand. As far as that goes, and as far as for everything, the electricity and everything, that I was given the runaround. I wasn't given any court dates. I wasn't given any certified mail. I got copies of the records for when they sent me certified mail. After the last time when I was told that I could finish the job, I wasn't informed, and this is the very first time that I was informed before the court date that I had to be here. I had my wife, because I work, try to just resolve the issue, and here I am. I feel we're going backwards. We've been going backwards since day one when, I've been trying to move forward.
Is the demo of the basement been completed?
It has not, because that was one of the things on the basement, was the demo. That was one of the things on the permit, but they decided to start with the other things so that I can get the apartment occupied, and that was the last thing they were going to address, but you had already shut it down.
And that was part of the inadequate drawings. How are they going to bring this basement to current code, meet those requirements?
Were permits
Drawings were
issued?
inadequate that they submitted were inadequate. They were informed as such. We never got any other drawings.
Were permits issued on the project?
Permit was issued for demolition of the basement and framing bring up to city code.
So your testimony is that you were furnished inadequate drawings and then you issued a permit based on those inadequate drawings.
Permit was issued first.
Why would we issue a permit before we got drawings?
He was trying to establish, Soto's General Construction was trying to establish fire separation. They put the ceiling up in the first floor, the 5-inch drywall, but it wasn't inspected, so we don't know what the condition is underneath the ceiling.
You were saying the drawings were for how to bring the other two units to code. The permit was for the removal of the illegal unit alone. That's the only permit.
On the drawing, the issue, the reason why they requested the drawing, they asked for a general drawing because the issue on the actual drawing was only the back door. But there's more permits here for the electric on the second floor, and it was signed off. They had the green tag to go ahead and move forward.
So we issued a permit on the basement, and then we stopped work on the basement. Is that?
Oh, thank you, Kurt. You see you come back in.
Sorry, Ms. Outside, it wasn't Attorney Murphy. A permit was issued to remove the basement apartment. I went there to inspect it. They were working upstairs on other apartments that there was no permit on. I stopped the work on everything other than the removal of the basement apartment. And there's action before the board on whether it's a 2-unit or 3-unit or what it is.
Do you have any other permits besides the permit?
Yeah,
to
if
remove
you
the
look, if
basement
you
apartment?
finish looking through, they issued electricity to do the electricity permit. So that's the very following page that he just passed up, and he just gave you one, not the other one. There it is. So he actually did give us a permit to do electricity. And that's when you got the green tag that it was okay. And like I said, I'm just trying to resolve this. I'm not trying to cause chaos.
So, Mr. Cook, the permit that he pulled was for the basement, he was working on the other one. Was he allowed to get a permit to work on the other ones then?
No. He
Okay, so none of those types of permits have been issued?
Right,
To work on the
right.
others?
There was an electrical permit issued at the board's direction. And I think Mr. Lindy's words were, if he wants to go ahead and do electric that may have to get torn out in the future, that's up to him. But it was at the board's direction to issue an electrical permit prior to the board reaching a decision on how many units were legal.
And that was going to be based on the drawings that they were to provide. The drawings they provided were inadequate.
I believe the confusion came in when the actual contractor came in. He gave them the whole entire list of the issues that were very cosmetic, really. And he just handed them the entire list, and then they gave him the permit. Did he fail to read the permit properly? Maybe he did, but it does not mean that we didn't try to pull the permits and the permits weren't okayed as far as them saying, go ahead. We just decided to start with the upstairs so we can get the apartments rented.
I believe code enforcement is saying it should be a 2-unit.
That's correct.
And he wants to have a 3 or a 4 unit. And that's what we've petitioned the board for, and it keeps getting pushed off, is that the decision, before we allow any further construction, the decision has to be made, is it a 2-unit or is it a 3-unit? Our position, Kelly's position, is that it's a 2-unit. His position is that it's a 3-unit. Once that decision is made by the board, because the difference between a 2-unit and a 3-unit.
I disagree. That matter hasn't been adjudicated by the board, so it shouldn't matter. We can't preclude an individual from pulling a permit to do construction in the city of Hammond based on a matter that has not yet been decided.
That's been decided.
The board is affirmed a 2-unit.
Right.
But they said they didn't get notice of that meeting, that hearing.
Not only
Then it hasn't been, then it was an improper ruling.
And Mr. Lindy, it's just like if you have a home and you can apply for a permit and say, I want to make it a McDonald's. I'm going to deny the permit for a variety of reasons, but the zoning, everything else. It's routine that you deny building permits to build things that are not legal. And our position always has been, is that what they have is not legal. And it was you that said, let them do whatever electric work they want. When we decide it, they may have to tear it back out. Because it's different.
Where's the 3rd unit at? In the basement?
There's 2 units on the 2nd floor, 1 unit on the 1st, and there's a basement apartment.
See, the problem arises, though, when you guys came to us and said the individual's been properly noticed, he's been serviced, and he failed to show up. And so we adjudicate the matter only to find out that the individual wasn't noticed at all.
Well, they were noticed because they brought several hearings, several meetings that they brought plans. They knew they had to bring plans. They said they didn't get.
Can you provide certified mail that the individual was noticed?
I would have to ask your secretary.
Well, you would have sent the letter, not the secretary.
No, it would have been set here. They didn't notify. We don't tell people when the hearings are. We don't know when the hearing's going to be set. We don't pick the date. That's you gentlemen.
They've been here 3 or 4 times. I mean, obviously, they've been noticed.
Well, I believe that we were notified of the first one, and that one, the very first initial one, we were given 1 certified letter. And then after that, when it was resolved, I assume when they said, go ahead and finish it, if you can finish in 30 days, do it. Then there was all these other dates I had no idea about. I'm just trying to find the right paper where it says that you guys only sent out 1 certified letter from the very beginning of this. I would never receive any other certified letters. And that's from downstairs. Right here. It just shows that we were only given 1 certified letter. The issue was resolved. I was not receiving anything after that. And then we called downstairs, and we were told by everybody there was nothing on. And then after the case, we were informed, oh, well, we had a case the other day on it. We had a hearing, and this happened. And we just kind of got strung along and drugged in a ditch that we didn't really want to be in. Now, I went to the building guy downstairs, and we looked, and he said his records as far back as he can go, the building was operating as a 3-unit, and as long as it could be brought up to code, that's what it should be. I think maybe the basement issue. I mean, as far as taking it out, I mean, we just need to be able to be allowed to move forward on it, and that would have been done. I just want to get the apartment rented because it's just sitting there.
Who in the building department determined these plans weren't sufficient?
In a variety of reasons. Number one, and I don't expect the board to understand this, but a 2-unit is addressed under the International Residential Building Code, which is an abbreviated set of codes. A 3-unit is addressed under the International Building Code, not the residential code, the building code. A whole entire different set of requirements. So I can't possibly review any plans until I know the legal status of it. And personally, whether it's a 2-unit or 3-unit, building-wise, doesn't make a lot of difference to me. But that has to be decided first. The plans also didn't show window sizes, door sizes, means of egress systems, anything that I would need to properly review a set of plans. But again, it's moved until it's put to bed. Is it a 2-unit or a 3-unit?
How do you guys not understand that we told this individual to take action and now we're coming and saying you shouldn't have taken action until something was determined? That is what you guys came here and said, that this individual needs to take action, he needs to spend money and have plans to me, and then we issued him a permit and now we're saying, you should not have done that.
Randy, if you look at the permits, the first permit was issued in October 2012. The electrical permit was December 2012. The hearing in January was where they needed to bring the drawings.
Okay, well, do you guys realize if I don't understand this, and I do this every week with you, and I have for the last 4 years, how is an individual supposed to understand this?
It was clear through many conversations that we were requesting to be, or wanted it to be a 2-unit. If you had any idea of making a 3 or 4-unit, and the request was a 4-unit, not a 3-unit, that you provide drawings on how you can make it a safe, to code, 4-unit. That has never happened.
Well, these engineering drawings show a 3-unit. They show multiple access points for all the units.
What is
They,
the code?
They
What
don't
is
show the window sizes.
dimensions and that is going to be code for commercial building.
When I requested the drawings, I requested them, I gave the guy who draws them up the paper, and he said, I'm gonna give them what they want. So he put all the information that they requested, and that's how he did it based on that. It wasn't that he didn't wanna add the other stuff that they were inadequate, that's how he requested. That's what we gave you.
What Kelly wants is it to be a 2-unit. What he wants is it to be a 3-unit. For me to do my job, you need to decide once, again, you've already decided once that it's a 2-unit. Now you want to rehear it, which is fine with us, on whether it's a 2-unit or a 3-unit. I cannot proceed further on my end, the building end, not code enforcement end, until I know the status of the property.
From this drawing, it appears that the second floor layout shows you 2 separate units that were built as 2 separate units. The thing in the basement, I don't know, I don't have enough information to make a decision on that, because I don't know what kind of windows that they have and access points.
You know, the property was originally built as a, according to Kelly's research, was originally built as a 2-unit.
That's
At
what
some
it
point in
looks
time.
like from this drawing.
Right, as a 2-unit, converted then from 2 units at some point in time to 4 units, actually,
Where was
basement.
the 4th unit?
In the basement,
The back part of the basement, or?
no, there was 1 in the basement,
One on the main floor.
2 on
The
the
second
second
floor is kind of a mirror image of the first floor, except it's got a wall separating it right down the middle.
right, and we're saying,
Inadequate fire separation, inadequate egress.
right,
Originally, but that's taken care of. When I went to talk to the guy, he looked back on his records, the same records I'm assuming Kelly looked at, and he said it's been operating since as far back as he could find as a 3-unit. As far as the 4th unit goes, the only reason why it was even a question was because they weren't sure if it could be brought up to code was the first issue. The second issue was the fact that who installed that basement apartment. But I have records of permits being pulled at one time before I even owned it for updates in the basement. So for them to say they were unaware and they don't, it just sounds, it doesn't match up to what the city says. The city says one thing and
It sounded to me like there's not quite enough information here, and maybe you guys need to get together and exchange additional information so that you can come to the board with a better recommendation, because I can't tell from this. It doesn't even show that there's a 1st floor. It says 2nd floor and basement.
right,
He might
and
just
you're
do
absolutely
that.
right, I can't issue a building permit based
let me
on
see.
information that I don't
I
have.
might have just not
Can
copied.
you guys work together and then come up with something and then come back to the board at a future date?
And I'm more than happy to.
think
I mean,
I got it.
remember, I'm in the building and he's code enforcement, and I'm more than happy to.
See,
But
Property owner,
until
did he
the
work with you
decision
guys?
is,
there is a second, there is, one's for the first floor, the other one's for the second floor, the basement. It's all there.
Yeah, but what's on the first floor? You got basement?
It's one big apartment on the first floor,
right.
and then there's a
First floor,
second floor is,
floor.
is two apartments,
That's a duplicate of that.
and then,
First floor
and then the
second floor
basement.
are virtually identical, other than the second floor was cut in half.
So do you guys have history of permits being pulled to convert it?
There was never a permit in our record books or in the zoning records of it ever being converted from a 2-unit to anything else. It was built as a 2-unit, and at some point in time was illegally converted from a 2-unit to a 3-unit and then a 4-unit. The basement apartment has been removed, am I right?
There's a permit for it, but no, it has not been.
Okay.
You guys have to work on it, because they were working on it before.
I believe ultimately, you know, we've been walking through this quicksand for a while, and I really need to resolve the issue. And if the initial from what I'm getting here is the fact of the basement, I'll gladly remove the basement. I just really need to move forward with this because we're just going in circles.
Well, now we've got the basement gone. Are you willing to convert the second floor into one apartment?
Well, the problem is that, you know, they're legal second floor apartments. They qualify for code, they qualify, they're updated, everything the way the city wrote on a piece of paper. I handed an electrician contractor the
Okay.
paperwork, I handed a regular contractor paperwork, and they do their job, and they come in, they pull the permits, and they did everything that they were under the impression they can do.
Right, that was when the board said, and it was you, Bobby, as you said, we haven't decided whether it's a 2-unit or 3-unit. They can do whatever electric they want. They may have to tear it out in the future when you decide.
I remember saying that.
Right.
I remember him agreeing
Right,
to it.
and it's fine. And if you said you think that Kelly is wrong and it should be a 3-unit, that doesn't bother us. I now know what to do.
No, but what bothers me is we told the gentleman that's what he's going to spend money to do. We told him to bring plans and spend money on creating plans.
Right.
And then we never noticed him that he was going to have a hearing on the 2 to 3 unit, except for somebody made a phone call and left a message on your machine. Is that how we noticed you?
After the date.
That's not proper. It's not correct. And I'm not going to make the gentleman spend more money because we improperly noticed him and then decided his case because he didn't show up because we left
It's
a message on his
obvious that he
answering
was
machine.
noticed because he's been here 4 times. So he's known about it. If you want to rehear it
We've
and make a
called in.
decision then, that's fine.
It's not proper. We're not going to have individuals spend money. Actually, I can't say that. I can't support. I don't know what the board's opinion on the matter is, but I can't support having an individual spend additional money based on the fact that we adjudicated as a decision when an individual didn't show up to our meeting because we called and left a message on somebody's answering machine, and that's how we noticed them. It's just not proper. That's not the way business is done. That's not the way major decisions for people's assets.
Are you saying you want another hearing? That's fine, we'll do another hearing. We'll bring back the file, the research and everything that goes with it. We'll start over, that's fine.
Well, we didn't have a hearing. We didn't have a hearing. You guys walked in front of us and said, yep, this individual didn't appear. We recommend that we tear this out.
Twice.
Not when we adjudicated whether or not it was a 2 or 3 unit, Kelly.
We were waiting for the plans to make it a legal 4-unit or a 3-unit that we could determine if it would even be able to be done. The only thing we have is a permit to put drywall on the ceiling that was never inspected in the first place. And electrical that was done for your recommendation that we don't know if it's going to be adequate for whatever, however many units this is going to be. To say that to take his word that we didn't give him service, there's been contact. I don't have any messages from him what's going on in my case, other than his wife calling saying, please give me a certified mail that we're having another hearing. If he was curious what was going on with this case, simply a call to me, law department.
I've called.
It's not his responsibility, it's ours. It's our responsibility to notice him. It is not his to call us to say, when am I supposed to be here? It's not. It's not. That's not the way, it's not our job. Our job is to facilitate residents and people doing business in the city.
Our last contact with
It's
him,
not.
the plans are inadequate a different set of standards for
Okay, well-
residential and for commercial. We told them bring us plans, never brought it. Hearings were set, we still didn't have any drawings. If you look back in the minutes, we said.
I have drawings from a professional engineer that it appears he probably spent a little bit of money to have drawn up. And then to be told we need something better. Did we specify to you what we meant by better?
When, I was never told they were inadequate until after all this started falling into place and we're issuing, the issues of calling and coming over. Then they started saying, well, the problem is this, well, the problem is that. The problem was brought up after the fact. It was never told before the fact. When I presented everything, nobody said a word. Finish the job. Can you finish in 30 days? Yes. That was the last word I received. Why would I think there was a court date? I wouldn't think that.
When they appear in front of the board and we issue a status date, do we send out certified mail when that status date is determined?
You guys are requesting it, yeah, the responsibility is yours.
Because I figured if the homeowner's here and make a decision and say, okay, we'll have a status set for this date, isn't that notice right there with the individual standing in front of the board? You tell them when he's standing in front of you and we're here too, like, okay, this is what you need to bring for the next hearing. Your next hearing will be such and such date. Is that not proper notice?
No, that's not proper notice.
All right.
We have plenty of people that you've seen stand up here whose primary first language isn't English. You've seen people stand up here with hearing impairments.
I just want to.
No, it's
So,
not proper notice.
so if you were to schedule a hearing with him today, we still have to go down and send him a registered mail about it. And we're arguing semantics. There's only three possible things, in my opinion, that you can do. Tell us it's a 2-unit, tell us a 3-unit, or schedule a hearing to give him adequate time to respond to Kelly's allegations.
That's what should have happened. We
Exactly.
should be running hearings that are just and equitable for all of the parties that are standing in front of us.
And we've been asking for that for some time. You said, give them an electric permit, we'll have a hearing later. That is what you said as president of this board. So we're asking for that hearing that you said we had to have, and now you're saying we don't notify them right. You want to have a hearing, you don't want to have a hearing, I personally don't care. But put me in a position that I can do my job. Tell me, is it a 2-unit or a 3-unit? Don't tell me I don't know which codes to enforce, because I know the codes like you know accounting. But until you make the decision once and for all on is it a 2-unit or a 3-unit, I can't do my job.
We can't make the decision without evidence.
Exactly,
Somebody schedule a
exactly.
hearing.
To schedule a
Right
hearing.
now, we're gonna have a dispute, you know, I'd really like you guys to go back and take a look at this,
Mhm.
and then come back with some kind of recommendation. And say, hey, we've determined that it can be a 3-unit, or we've determined that it can't. Based on the following facts.
I'm happy to look at it. But anything can be. Can it be a 3-unit? Yeah, it can be a 3-unit. Does it mean that-
Does it meet the zoning? Those are the questions.
Yeah,
that
no,
need-
it's zoned R1U, which is a 2-unit. It's not zoned for a 3-unit. So that is a no. Does it meet building codes? Building codes at what time? Today's building codes, it would not be allowed, period. As a 3-unit, it would have to have a sprinkler system. It would have to have 2 more water lines run in from the street, backflow valves installed. It would have to have more work needed to convert it to a 3-unit on today's building codes than it would cost to tear it down and build it new. So, again, Kelly wants to represent their evidence on showing why we feel it should be a 2-unit. He wants to present his evidence on it being a 3-unit.
I mean, what we did though, we did touch all bases on all the things and issues that they said. And originally, they said it was the back doors, the way they swung open, because when they designed them on an angle. We fixed that. And then they said the firewall separation. We fixed that. Along the way, they brought up the electricity. We dealt with it. And now they say, no, no, no. While you weren't here, we were deciding this. And it just seems unfair. It seems
As in any case,
unjust.
we show them, we tell them, and show them if they're there, what the problem is. In this case, there's egress in two apartments, basically emptied into each other, did not meet the code, okay? Yeah, we told them about fire separation. Also can tell them about balloon frame construction that doesn't have firebox at every horizontal or every 10 feet. So there's other things that go in as contractors come in and, for instance, remove that ceiling on the first floor that are required. If that inspection isn't done, we don't know if there's not a tube wire in there that is, once it's exposed, has to be upgraded. We don't know if that happened. We never did an inspection on it. So yeah, there's a permit, but there's never any inspections. There's other things that come into play, in place, especially if it's gonna go to a 3-unit, and commercial codes come into place.
I have a final inspection tag for the electricity.
For electricity, absolutely.
I'd like to make a motion that we vacate the decision that was made based on the fact that there wasn't adequate notice given to the property owner.
Any further discussion? All in favor?
Aye.
Aye.
So how do we proceed? We having another hearing?
Well, you can meet with the property owner, see if you can work something out. If you can't, then you can schedule a brand new hearing. Make sure you've noticed correctly this time. Did you want your copy back?
Well, I actually gave it to Kelly.
Because you gave us 2. You want to go back?
Back to item G.
Please.
Item G, 232 to 34 Ogden. I hope this goes easier.
Good morning, members of the board. For the purpose of the record, I am Justin Murphy. I am appearing with my client, Mr. Goldsmith. There was citations issued in this matter. I have moved to continue this hearing on numerous occasions, I believe since March. In the interim, we have met with the city. We believe we have amicably resolved all issues, and I believe the city is moving to dismiss today.
Yeah, I appreciate the board's help in the matter. He still needs a final inspection, but I have no objections to dismissing action, and I'll work out the details.
Is there a motion to dismiss any action at 232 to 34 Ogden?
So moved.
All in favor?
Aye.
Aye. Motion carries.
Thank you, members of the board.
Thank you. Item I, 1459 Truman.
He's about 99.9% done on the project, thanks to the board's little push you gave him last month. Does need final inspections done. I do need to get water service reestablished. So I'd like to set this for status in 30 days.
Oh, that's way plenty. Yes, sir.
What's your recommendation?
Status in 30 days. He's so close to being done. It's
Motion to have status in 30 days.
And with the board's permission, if he does pass all the final inspections, I don't think there's any need for him to return in 30 days. I'll just tell you everything is fine and have it dismissed.
It's a motion by Mr. DeStatney. Is there a second? Second. All in favor? Aye. Motion carries.
Thank you, board.
Item J, we have an agreement to rehabilitate the property at 6317 Monroe and 6320 Harrison and 5661 Soul.
I just want to point one thing out to the board that's slightly different than what you had agreed to in the past. We had asked for a $10,000 bond on each property. She doesn't have the financial resources to do so, was not able to secure a bond. But I did meet with her yesterday. She brought in $10,000 cashier's check, gave to the controller's office. We're going to use that one $10,000 for both properties, as opposed to two $10,000 ones. I'm sorry, 6317 Monroe, 6320 Harrison is the one I'm talking about. 5661 Soul is a different owner.
this agreement prepared by our attorney or by her
By our
attorney?
attorney, by Ms. Cantor.
Is there a motion to accept the agreement?
So moved.
Second.
All in favor?
Aye.
Aye. Motion carries. Item K, we have correspondence requesting a rental registration hearing. Property located at 4717 Ash. No, they're requesting a hearing date, not, this isn't the hearing. Whatever.
August 15th.
Set for August 15th. Item L. We have correspondence from Ms. Gutierrez requesting a hearing appealing the denial of her business license for Real Tea Tattoos at 7118 Calumet.
When do you want to schedule that? 2 weeks?
August 15th.
August 15th. Item M. We have correspondence from Ms. Estrella requesting a hearing to appeal the denial of her business license at Estrella Sports Bar at 4704 Homan. You're here.
Yeah,
Ms. Estrella, your business license was denied based on a background check
because I have a felony and it's my ex-husband's business, but I don't know the reason why they put it in my name, so I brought the contract from my lawyer showing that I have no ownership whatsoever in the bar.
So this isn't your bar.
No, it's not. So that's why when I received the letter, and it even has my last name wrong on Miss Gutierrez. I don't know who that was for.
So this license was obtained in your name.
It had my ex-husband's name on there, but for some reason he wrote my name on the bottom of the paper. So they called me and asked me my birth date on the phone, so I didn't know what it was for. And I gave him my birth date, and I guess they went ahead and ran a background check and tried to put it into my name. And I'm not sure the reason why, because I have no ownership in the property.
Ah, okay.
And I have the paper. I don't know if you want to see the paper from the lawyer for the contract.
She applied for the license?
No.
So you have no affiliation with this place at all?
No, and I have this.
Fantastic. All right. Don't need that. Why don't one of you make a motion that this be referred to the police department to investigate the fraudulent obtaining of a business license, and that we have a business operating in the city of Hammond based on fraudulent information that was filed with the controller's office?
No, he didn't fraudulently. I was with him when he filed it, but it wasn't supposed to have my name to do with anything because I knew that I'm not the owner, that I didn't want the license in my name. So they even took a copy of his ID with his information. But I guess when he filled out the information, he put that I was a co-owner, and I guess he didn't read the application right. And I'm not the co-owner. That's the reason I wrote the letter, and I brought proof in showing I have no ownership.
So you and your ex-husband came and obtained the business license together?
But I came with him to let him fill it out, to show him where it was filled out.
I see.
But I knew that I couldn't even, that's why I didn't even put my name on anything, because I knew.
What is your correct name? Is your correct
Melissa
last name
Estrella.
Estrella?
Yeah.
Do you also go by Melissa Ochoa?
That's his, like, because he's Mexican, so they carry the two last names.
Okay, do you also go by Melissa Barnett?
No, that's my married, that was my dad's.
Do you also go by Melissa White?
My mom's name is White, and then my mom changed my name to my dad's last name, which was Barnett. So Estrella is my married name, which I kept when I got divorced. I mean, I have my ID.
Is it your testimony then that this is not an appeal of the revocation of the business license? This is just simply you're noticing the board that you have no involvement in this business. Is that correct?
I'm just, well, pretty much I'm here for him too, because, I mean, it wasn't supposed to be in my name, it was supposed to be in his. So the reason it got denied is because they ran it into my name, and it wasn't supposed to be like that.
So are you representing the owner then today?
Yeah,
Okay. Is it your intent then to appeal the decision of the board to revoke the business license?
correct,
When would you like to have that hearing?
as soon as possible.
August 15th?
August
That's
15th?
fine, that's fine.
All right.
Okay.
You know what happened there, right? No. Item N. Correspondence from Councilman Higgs requesting certain trees be removed in his district. And also that certain sidewalks be repaired in his district. Well, replaced. Is there a motion to refer this to the Park Department and the Engineering Department?
So moved.
Second.
All in favor?
Aye.
Aye. Item O, we have correspondence from Hammond Parks Department requesting the closure of 169th Street and 175th Street for the annual holiday parade in December.
I'll make a motion that we approve the request.
Second.
All in favor?
Aye.
Aye. Item P, we have correspondence from Dayspring Ministries requesting a back-to-school health fair street closure on Maywood Street between Sibley and State Street on August 17th from 10 a.m. to 4 p.m.
Yeah, we approved this previously, but they didn't explain it properly. Oh, no, that's the next one. Sorry. I'll make a motion that we approve P.
Is there a second? All in favor? Aye. Motion carries. Item Q, we have a request for a block party at 240 Hanover.
I'd like to make a motion that be referred to the police department.
Second.
All in favor? Aye. Motion carries. Item R. Item R, we have a request for barricades at a block party.
Yeah, we've actually approved the party. It's really not a block party, right? It's a church function. And they wanted to request barricades, and the street department wouldn't do it because it wasn't part of their original request. So I'd like to make a motion that we approve the use of barricades for this event.
Second.
All in favor? Aye. Motion carries. Item S, we have correspondence from the 6700 block of Alabama with a petition to hold a block party from 2 p.m. to 10 p.m. on August 31st.
Make a motion that be referred to the police department. Second. For recommendation.
All in favor? Aye. Motion carries. Item T. Yeah, I'm missing some paperwork though. Item T, we have the recommendation from the building department to award the demolition of approximately 20 properties. In the tabulation, it was determined by this board that Acton TRI was not the lowest responsive and responsible bidder. Based on our experience with them on the demolition of several properties, including 7004 Monroe, the Wonder Bread Building, and the Masonic Temple, where they were found to be
That's the correct term.
No, it's not the correct term. You have that correspondence, please? I know, it went somewhere in that paperwork.
Maybe right up on top. Right at the bottom. What's it?
They were found not to be competent in their execution of the bid awards on those 3 projects. As such, their bids were rejected, and the bids were then awarded to the lowest bidder in each of the several cases.
We can go with that.
Isn't that good? That's what the statute says.
Oh, you're right. I'm sorry.
That's all right. Is there a motion by the board to award the bids?
So the bid award was based on the lowest bidders for the individual properties. So it's been awarded to, what, 3 different companies?
Correct.
So I'd like to make a motion that we concur with the recommendation for the low bidders on the demolition bid of 7/11/13. Second.
All in favor? Aye. Aye. Motion carries. Item U, we have several garage sale permits for approval.
Make a motion that we approve them all.
Second.
All in favor?
Aye.
Aye. Motion carries. Item 6, is there any other matters from board members? Is there any new or old business? Item 10, public expression. The meeting is now open to the public. Anybody from the public wishing to address the board, now is your opportunity to do so. Item 11.
We adjourn.
Second.
All in favor? Aye.